Hey folks, welcome back to the channel. In today's proceedings, a level 7 felony charge of aggravated domestic battery is weighed against the smooth performance of a defendant who knows exactly how to act before the bench. The evidence paints a picture of a violent, terrifying encounter, strangulation, dragging, and threats of unaliving. But before the judge, he trades rage for restraint. He's cooperative, polite, and careful in every response. That polished routine sets the stage for a plea that sidesteps the word guilty. Let's watch what passes for justice when you know exactly which box to check.
Sweet. Elk County case number 2025 CR9. Jill Gillette appears as Elk County attorney. William McClendon as defense counsel. Defendant Swede appears at the Elk County Sheriff's Office Zoom location. Comes before the court at this time for arraignment. Court noting the journal entry of preliminary hearing filed in this case would indicate that the matter came before the court on June 25 of 2025. At that time, there was waiver of preliminary hearing rights, and the matter is set over to today for arraignment. Mr. McClendon, does your client desire the charging document to be read to him?
No, Your Honor, we'd waive, and the state and I have reached an agreement on this matter.
All right, what's the agreement?
Yes, Your Honor. My client would plead no contest to count 1 aggravated domestic battery. In exchange for that, counts 2 and 3 would be dismissed.
All right, Ms. Gillette, is that correct?
That is correct, Your Honor.
All right. Mr. Sweet, apparently at this arraignment, you're going to be entering a plea of no contest and therefore accepting conviction for aggravated domestic battery, a severity level 7 person felony. Is that indeed your intention?
Yes, Your Honor.
All right, I've got a number of questions I need to ask you regarding the taking of a plea of no contest. If there's anything asked of you that you do not fully understand, I will give you the opportunity to confer with your attorney privately. Just let the court know if you need that conference time, okay?
Okay.
State your full legal name for the record.
Wrangler Floyd Garrett Sweet,
All right, and how old are you right now?
32 years old,
What's the highest level of education that you've attained?
grade 9.
Do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here this afternoon?
No,
All right. Have you ever been adjudged to be mentally ill?
no,
Are you currently under the influence of alcohol or any drug?
no, sir.
Are you currently taking any type of mental health related medication?
No,
Are you supposed to be taking any such medication that you are not currently getting?
no,
So as you sit today, do you believe your mind is clear and that you have a full understanding of what's going on here in court?
yes, Your Honor.
All right. Did you receive a copy of the original charges in the case?
Yes,
Do you understand the nature of the charge in count 1 of your information, which is aggravated domestic battery?
yes,
You understand that when you enter a plea of no contest, you do not necessarily admit that you did that act, but you're also not contesting that you be convicted just the same. Do you understand that?
I understand.
You also understand that when you enter a plea of no contest, you give up any legal defenses that you might have had to that charge.
I understand.
All right. Mr. Sweet, do you understand that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, and that you could present evidence on your own behalf at your trial and subpoena your own witnesses to court?
Yes,
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that you could testify in your case at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
I understand.
All right. And you understand that when you enter a plea of no contest, you give up these valuable trial rights that the court has described.
Yes,
You also understand that you have a right to a trial by jury, and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt.
Yes, I understand.
Okay. You understand that when you enter a plea of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yeah, I understand, Your Honor.
You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes,
You further understand that you may appeal your sentence after entering a plea of no contest, but generally, you may not appeal your judgment of conviction after you enter such a plea.
yeah, I understand.
Sweet, do you understand the penalties that could be imposed as a result of this no contest plea that you're attempting to make?
Yes,
Well, let's go over those. This is a level 7 person felony crime in Kansas on the level 7 line on the non-drug offense grid under the Kansas Sentencing Guidelines Act. In the most favorable criminal history category of I, you could receive as little as an 11-month sentence. In the worst criminal history category of A, you could receive up to a 34-month prison sentence. So the sentencing range is 11 to 34 months in prison, depending on your criminal history. As you sit today, Mr. Sweet, we do not know with certainty what your criminal history is. You better than anyone else here should really know what your own criminal record looks like. Without being researched by the Court Services Department, and based on the outcome of their research as of the date of sentencing, that will determine where you fall along the level 7 line, and then you'll be sentenced accordingly. Do you understand that?
yes,
Mr. Sweet, do you also understand that if you have 2 or more person felonies on your record at time of sentencing, you would be presumptive prison here?
yeah, I understand.
You also understand that you could receive up to a $100,000 fine for this offense.
I understand.
In addition to any fine, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
I understand.
You also
Yeah.
understand that as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision as deemed appropriate by the court at time of sentencing.
Yes,
You also understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
yes,
Do you understand that the Kansas Sentencing Guidelines Act contains many special sentencing rules? Do you understand that if any special sentencing rule applies to you in your situation, it could affect your eligibility for probation or otherwise affect your sentence?
yes,
Right? Have you had an ample opportunity to discuss fully legal matters like that with your attorney, Mr. McClendon, before proceeding here today?
yes, I have.
You want any more time with him now privately before we go any further?
No, thank you.
Okay. Are you satisfied with the services and advice given to you by your lawyer?
Yes,
Now, this no contest plea that you're attempting to make hasn't been based upon any threat or promises as to what this court will do in regards to your sentence or any other type of threat or promise?
no,
Okay. You understand that if there are any plea deals between your counsel and the county attorney's office regarding sentencing recommendations, this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. You understand that?
yes,
So let me ask you, how do you formally plead to the charge in count 1, aggravated domestic battery, a level 7 person felony?
I plead no contest.
I'll ask the state's attorney to provide a concise factual basis for that offense.
Your Honor, Under Sheriff Young on May 12th of 2025 was dispatched about 2 o'clock in the morning from a call from Miss Shelley Vanderhagen in Granola, Kansas. Shot in loud banging on the door and a female yelling for help. They went to the area and they had talked with the neighbors. They had found Nola Majestic Cartwright. She had been involved in a domestic assault and that she was the one banging on the door. When there's no answer, she went over to Todd Sweet's house, who's her boyfriend's dad. The boyfriend being Wrangler Sweet here, and that he was in a dating relationship with the victim. They talked to Magic. She was standing in the middle of the road. She had blood on her head, bumps and bruises forming on either side of her face and temples. She had blood in her hair and blood coming out of her mouth, and red marks on her neck that looked like ligature type of strangled marks from hands. And she had relayed that she'd just gotten back from visiting with her mother and had gotten into an argument. And it ended up getting physical, where he had hit her, drug her out of the chair, was screaming at her. He ended up choking her, cutting off her airway, and she believed that she was going to die. And he was stating that she was going to die. Majestic used her hands to start hitting away to try to get out, and he had headbutted her. Then she had ended up running for help.
Okay,
She
I
had
think, I think you've got that covered. Where did this allegedly take place at?
Granola, Kansas, within the bounds of Elk County.
Okay, all right. Thank you, Ms. Gillette. All right, Mr. Sweet, do you now freely, knowingly, and voluntarily enter a plea of no contest and accept conviction for the crime charged in count 1, aggravated domestic battery, a level 7 person felony?
Yes.
Mr. McClendon, do you know of any legal reason why the court shouldn't accept your client's plea?
No, Your Honor.
Ms. Gillette, do you know of any legal reason why the court shouldn't accept this defendant's plea?
We do not, Your Honor.
All right, Mr. Sweet, do you know of any legal reason or any other good reason why the court shouldn't accept your plea of no contest at this time?
I do not.
Court will accept the no contest plea made by defendant Wrangler Sweet and finds that that plea is made voluntarily. He has an understanding of the nature of the charge and the consequences of the plea, and a factual basis for the plea does exist. The court finds him guilty and adjudges him therefore convicted of the crime of aggravated domestic battery, a severity level 7 person felony. Pursuant to plea agreement, counts 2 and 3 are dismissed. The court will order a pre-sentence report be completed to accurately determine this defendant's criminal history, and the court will set an appropriate date for sentencing.
Judge, we have thoroughly looked over registration. I do not believe this specific crime falls under registration, but it does have to have a finding by a trier of fact and or court on accepting a proffer as to whether or not this is a domestic violence offense that should have a DV designation that requires VIP.
This case should have a domestic violence designation, counsel. The court so finds they were previously in a domestic relationship, dating relationship, if you will, and therefore qualifies the case for a domestic violence tag. And this is a registration offense, Ms. Gillette?
It is not a registration offense.
All right.
We were prepared in case it was, but
All right.
it's not.
Mr. Sweet, I'm going to need you to contact the Court Services Department. I'm going to go ahead and have you write down the main office number in El Dorado.
Okay.
You got a pen and a paper there?
Yeah.
Okay, it's area code 316-322.
What was that starting from the beginning?
Area code 316
Okay.
322-4153. And that's the
Alright.
Court Services Department. And then they will, you just tell them what you just pled to, and they'll give you further direction as to what you need to do to complete the pre-sentence process. Now, Mr. Sweet, you may be asked to do one or more assessments as part of the pre-sentence investigation. Your face is off screen right now.
Oh, sorry.
You're going to need to make sure that whatever assessments you need are determined, scheduled, and completed prior to your sentencing, because I'll hold you responsible if you don't get your assessments done and we have to delay the sentencing. I
Okay.
just don't want that to happen. All right, so I'm going to go ahead and set a sentencing date in the case for the month of October. Specifically Thursday, October 9. You'll need to appear at the Elk County Sheriff's Office again where you are today, Mr. Sweet, to participate in your sentencing and no other location.
Okay.
October the 9th. Mr. McClendon, do you have any scheduling conflicts on that date?
No, Your Honor, I'm available all day at that, surprisingly.
All right. I'm going to set this at 11 o'clock a.m. Sentencing in the Sweet case is set for Thursday, October 9, 11 o'clock a.m. with the defendant ordered to appear at the Elk County Sheriff's Office to participate from that location. Go ahead and make that call as soon as you can after court's over with, Mr. Sweet, and go ahead and get off to a good start with your pre-sentence investigation process.
Okay.
All right, Ms. Gillette, is there anything further that the court needs to address regarding this case at this time?
Your Honor, he has been on GPS as a requirement of his bond. I am okay with lifting the GPS as of today. He has cooperated and taken responsibility for his actions. In fact, this is his third hearing. He immediately waived prelim and has taken responsibility for his actions. I hope that shows me he's trying to make strides to make changes in his life. So I'm okay with taking off the GPS as long as he does not go near or around the victim in this matter.
Majestic Cartwright. Correct?
Correct.
All right.
Yes.
Anything you want to say about that, Mr. McClendon?
Your Honor, I'd reflect the same sentiments, and we'd be asking that he has his ankle monitor removed.
All right, Mr. Sweet, the court's going to make that order at this time. Your GPS device can be removed at this point with the understanding that you've got a no contact, no communication restriction between yourself and the victim in this case, Majestic Cartwright. We
Okay.
can't have any problems and we can't have you and her in the same place at any time.
Judge, is he directed to be back at the sheriff's office for sentencing?
He is. Told him very specifically that. Any questions here, Mr. Sweet?
No.
All right. Again, counsel, either one of you, is there anything further we need to address?
No, Your Honor.
All right. Very well then. Go ahead and make that call, Mr. Sweet, as soon as we get done. If there's nothing further, the Wrangler Sweet matter.
No contest may streamline the process, but here sterilizes the violence into a clean conviction on paper. Physical injuries confirm the story, leaving little room for doubt about the violence. But being legally allowed to sidestep direct admission creates an escape hatch for responsibility. Even the ankle monitor comes off, making violence look procedural instead of life-threatening. It raises the uncomfortable point. How can a plea that avoids admitting guilt be acceptable in a case like this? Are they just legal shortcuts with the same sentencing grade attached? Let me know your thoughts in the comments. And don't forget to like, subscribe, and hit that notification bell for more gripping courtroom moments. Thank you for watching. See you in the next one.